A lot of movement on the Ghislaine Maxwell front after the bombshell news from the DOJ, FBI regarding no Epstein client list and all this talk about whether her sex trafficking conviction should be thrown out. A, it's being reported that she would be willing to testify to Congress. What? And B, the Department of Justice has just responded in a very big way to her bid to get her conviction tossed out. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is a Law&Crime legal alert. If you received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. That's right, Morgan & Morgan, they're investigating claims that patients weren't properly warned about this risk. It's free to check, just takes a few minutes, and you don't pay unless they win. So scan the QR code on screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. We just talked about Ghislaine Maxwell on a previous Sidebar and whether the bombshell revelation from the DOJ and the FBI regarding Epstein's death and a lack of a client list would affect her conviction. Would it get tossed out? And now she is once again in the headlines as the federal government has officially filed its response to her appeal of her criminal conviction. So I'm going to lay all this out. We're going to talk about it. And we're talking about Ghislaine Maxwell, right? The 63-year-old Jeffrey Epstein, former associate who was convicted in December of 2021 in New York federal court of conspiracy to entice minors to travel to engage in illegal sex acts, conspiracy to transport minors to participate in illegal sex acts, transporting a minor to participate in illegal sex acts, and sex trafficking conspiracy and sex trafficking of a minor, as the government argued. And she has been appealing that conviction through the courts and arguing that basically she should never have been prosecuted because her argument is she was legally protected. Now, how does she argue that? Well, this all comes back to Jeffrey Epstein. So Jeffrey Epstein, of course, was the deceased financier and convicted sex offender, the man accused of being one of the most prolific and infamous sex traffickers of all time, who died in a New York City jail in August of 2019. And also, we can't forget about his infamous non-prosecution agreement that has come back into question today. That's going to be the focus of our conversation. And this was arranged in Florida for Epstein back in 2007 between him and federal prosecutors. There was a grand jury that ended up indicting Epstein in 2006 on felony solicitation of a prostitute. And that was it. There have long been arguments about this. Why didn't prosecutors pursue more aggressive charges? Why was this the only one? And of course, we know how this went, right? The Palm Beach Police Department chief and lead detective, they were particularly troubled by this state prosecution. So what do? They refer the matter to the FBI, who brings it to the assistant U.S. attorney. So now the feds are involved. And in the end, in 2008, Epstein and prosecutors, they worked out a deal where he pled guilty to state charges of solicitation of prostitution and procurement of minors. He's sentenced to 18 months in prison, only serves 13, spends most of the time in a work release program where he can leave the jail to work at his office and then goes back to jail at night, and he avoids federal charges. He had to register as a sex offender too. This is the whole sweetheart deal. That is until he was federally indicted in New York in 2019, charging him with sex trafficking of minors. Now, unless he worked out another deal, by all accounts, he would have gone to trial. But again, he died in his jail cell. Well, now, Ghislaine Maxwell has been using that to say, hey, I was covered by that deal. My conviction should be overturned. Why? Because as the DOJ explains in their memo from yesterday, which is what we're going to talk about, quote, a later provision, so in the non-prosecution agreement, a later provision stated that if Epstein, quote, successfully fulfills all of the terms and conditions of this agreement, the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including, but not limited to, 4 of Epstein's assistants, none of whom, by the way, is actually Ghislaine Maxwell. It's an interesting argument, right? So that's what we're going to discuss. And by the way, this is all coming against the backdrop of a lot of controversy when last week the Department of Justice, the FBI, released a memo stating how after a, quote, exhaustive review of a lot of the evidence in the Epstein case, digital evidence, physical evidence, including the files relating to Epstein, including a large volume of images of Epstein, images and videos of victims who are either minors or appear to be minors, and over, 10,000 downloaded videos and images of illegal child sex abuse material and other pornography, they concluded there was, quote, no incriminating client list, and there was also no credible evidence found that Epstein blackmailed prominent individuals, and they didn't uncover evidence that could, quote, predicate an investigation against uncharged third parties. Essentially, no one else is going to be arrested or prosecuted at this point. There's no one else a part of this other than Maxwell and Epstein. And they also concluded that he died by his own hand. Okay. This blew up social media. This blew up the political world. There have been accusations of cover-ups. That has been mounting, particularly after the stance of Attorney General Pam Bondi and other Trump officials. You know, the idea that names will come out. Pam Bondi had stated that the list of Jeffrey Epstein clients is sitting on my desk right now. A lot going on with calls that Bondi be removed. There has been a reported falling out between Deputy Director of the FBI Dan Bongino and Pam Bondi over the Epstein files announcement. And our past sidebar was about, does Ghislaine Maxwell have legal grounds to say, hey, my conviction should be overturned based on this announcement? Because as we discussed in the previous sidebar, probably doesn't have a strong legal argument for that. You know, the idea, who else did if there's nobody else that a part of it, who did I sex traffic these victims to? Well, the argument was you sex trafficked them to Jeffrey Epstein. That's sufficient. That's what the prosecution argued. But we've been talking about this. There's a lot happening now, and her name is back in the news because of what happened yesterday, okay? The government responded to her appeal. I want to bring in right now Alexis Rosenberg, trial attorney, federal litigator, to talk more about this. Alexis, thank you so much for coming on. Before we talk about the government's response to her appeal, I got to get your opinion. First off, okay, this is your term to jump in the mix. Is there anything on the face from what the DOJ and the FBI said in their memo last week that directly affects Maxwell's criminal conviction? In other words, well, no one else is getting prosecuted. There's no client list. Why was she convicted? Why was she the only one brought to trial and convicted? Who did she sex traffic minors to? Is there anything from that announcement that affects her conviction?
Well, first, Jesse, thank you for having me on. And I'm going to get to that, but I want to jump in about this client list. It screams to me, Clinton, I did not sleep with that woman. I think it's a use. Is there an actual list with clients' names on it? Probably not. But how about if we just go through his contact list and start there? I'm sure we could get a list from that. So getting to your question, I definitely think that doesn't necessarily, and you kind of touched on it, affect the conviction, because we can jump into later, I'm sure, why that is from the legality of what's been the question that's certified to the Supreme Court. But you're correct. If she doesn't have to traffic these girls to multiple people. Simply trafficking the girls to Epstein is enough to let that conviction stand. So now we get to the next question about this non-prosecution agreement.
And I don't even think that they have necessarily been mounting the argument that announcement affects her conviction per se, although I'll talk about that. Actually, taking a section from the DOJ's response to Maxwell's appeal, I thought that this was an interesting example of summarizing what the prosecution's case against Ghislaine Maxwell was. And it was all about Epstein. It was all about trafficking victims to Epstein. No other alleged co-conspirators or clients or accomplices, because it said, again, this is from the DOJ's response, quote, from about 1994 to 2004, petitioner, this is meaning Ghislaine Maxwell, coordinated, facilitated, and contributed to the multimillionaire financier Jeffrey Epstein's sexual abuse of numerous young women and underage girls. The abuse followed a pattern. Petitioner and Epstein would identify vulnerable girls living under difficult circumstances, isolate them from their friends and families, gaining their trust by giving them gifts and pretending to be their friends, normalize the discussion of sexual topics and sexual touching with the girls, and then transition to sexual abuse, often through the pretext of a girl giving Epstein a massage. Petitioner and Epstein paid victims large amounts of cash to provide Epstein, nobody else, to provide Epstein with sexualized massages, and after a victim had begun giving massages, they would offer her additional money to recruit other girls. Petitioner and Epstein carried on those activities at, among other locations, Epstein's residences in Palm Beach, Florida, and New York City. Now, Alexis, it was reported in the Daily Mail that a reported source to Maxwell told the Daily Mail, despite the rumors, quote, despite the rumors, Ghislaine was never offered any kind of plea deal. She would be more than happy to sit before Congress and tell her story. No one from the government has ever asked her to share what she knows. She remains the only person to be jailed in connection to Epstein, and she would welcome the chance to tell the American public the truth. Interesting timing of that. What do you make of that statement? What's the aim there, if that's true?
Well, I would like to hear what she has to say personally. I think the aim is to show that they're trying to hide something, that they don't want her to talk. They're trying to silence her. And this goes along with the conspiracy that Epstein was actually murdered and he didn't commit suicide. So I think that's the aim of that. And by the way, they don't, there's no obligation that they have to offer someone a plea either. So that they're not required to do that. And so everybody knows, when you're trafficking minors, you could potentially send life in prison, not 20 years. And there were various counts on this as well. So that should be kept in mind as well.
Okay, let's talk about what happened yesterday. So the DOJ, they responded yesterday to Maxwell's appeal, asking the Supreme Court to deny Maxwell's appeal. This is again after the Second Circuit Court of Appeals, a lower court, had rejected Maxwell's argument. So they're saying to the Supreme Court, don't pick up this case. And yesterday, by the way, was the deadline for the DOJ to respond. And they're basically saying to the Supreme Court, deny what we call in the law writ of certiorari. Don't even hear this case. Now, before we even get into the DOJ's argument, I am curious, Alexis, what you think about Maxwell's attorneys, because they argued well, not their attorneys per se, but basically their position, their argument, because they argued in a prior petition, quote, despite the existence of a non-prosecution agreement promising in plain language that the United States would not prosecute any co-conspirator of Jeffrey Epstein, the United States in fact prosecuted Ghislaine Maxwell as a co-conspirator of Jeffrey Epstein. And defense attorney David Marcus wrote in the court paperwork, a defendant should be able to rely on a promise that the United States will not prosecute again without being subject to a gotcha in some other jurisdiction that chooses to interpret that plain language promise in some other way. So Alexis, let's start there. Before we go into the DOJ's response, is that a fair argument? Is that a fair defense?
I don't think so. I think here's the problem. The bottom line is that one district cannot bind another district. We also need to understand this was a non-prosecution agreement in federal court. He was ultimately pled. This wasn't a plea agreement to state charges. So, and also you need to understand that you can be charged in federal court and state court for the exact same crime. A lot of people don't realize that. So the argument, I believe, is very strong that this agreement that was made in the Southern District, which is a federal court in Florida, is binding on the Southern District. It is not binding on crimes that they're alleging were committed in the state of New York and brought by a New York federal court. And that is the argument. And I think that's a strong argument, coupled with the fact that these are different crimes. This isn't even the same crime. This is a crime that New York's alleging that these crimes took place in New York. And that's what he's being prosecuted for, and what the Southern District were for the crimes that allegedly took place in his home in Palm Beach in Florida.
You're echoing a lot of what the DOJ said in response, and I want to get into the specifics of what they said. I will ask you, though, in a recent comment, okay, so Attorney Marcus, so I believe this is right after, or this came out after the DOJ and the FBI's announcement, when I said they didn't, they're not making an argument directly in relation to the DOJ and FBI saying there's no client list. I thought this comment was interesting. Quote, I'd be surprised if President Trump knew his lawyers were asking the Supreme Court to let the government break a deal. He's the ultimate deal maker, and I'm sure he'd agree that when the United States gives its word, it should keep it. With all the talk about who's being prosecuted and who isn't, It's especially unfair that Ghislaine Maxwell remains in prison based on a promise the government made and broke. Interesting statement, no?
Well, I mean, I think many people in New York believe that Donald Trump is the ultimate deal breaker. So, I mean, I don't know that that's so interesting that he's making that statement.
Well, let's talk about it. So now let's get into the DOJ's response, where they argue that Maxwell's argument that Epstein's non-prosecution agreement, or NPA, with the U.S. Attorney for the Southern District of Florida barred her prosecution by the U.S. Attorney for the Southern District of New York. They say it is, quote, incorrect. That argument is incorrect. Why? So the DOJ argues that that co-conspirators clause in Epstein's NPA, non-prosecution agreement, was, quote, highly unusual and, quote, appears to have been added with little discussion or consideration by the prosecutors. During a later investigation into the Florida USAO's handling of the Epstein matter, the assistant U.S. attorney who handled the case told the Department of Justice's Office of Professional Responsibility that she did not consider the possibility that Epstein might be trying to protect anyone other than the 4 named assistants. And other USAO attorneys suggested that the co-conspirators clause was meant to protect named co-conspirators who were also victims of Epstein. So, Alexis, that argument is it's limited, that it doesn't even apply to a Ghislaine Maxwell, that she wasn't even identified.
Well, but I think there's a catch-all that says co-conspirators, so they don't
Sure.
necessarily have to be specifically named. I don't know if that is such a strong argument. Definitely you would throw that into the pleading as part of or the reply as part of the argument. But I don't think that's the strongest argument that we have going on. I think that it's just not binding across multiple districts, as well as that we're talking about other crimes. But you know, a bigger thing that, Jesse, we need to look at is, you know, I keep asking, why did New York take so long to bring these charges? Because they could have brought them at the same time. They could have brought them right when this went down back in 2008 or any time in between. I mean, there's a huge gap. We're talking 2020, 19 and 2021. There's a huge gap in time.
Absolutely. When a lot of the allegations stemmed, much before 2019. It wasn't like, hey, we had to wait to 2019 to find criminal conduct. They were ready to go after him for things that happened years earlier, allegedly happened years earlier. So go back to the other arguments. Again, this is something you previewed. They say in their response to Ghislaine Maxwell's appeal, quote, DOJ policy provided at that time and similarly provides today that no district or division shall make any agreement, including any agreement not to prosecute, which purports to bind any other district or districts or division without the express written approval of the United States attorneys in each affected district and or the Assistant Attorney General of the Criminal Division. Non-prosecution agreements, like plea bargains, are contractual in nature and are therefore interpreted in accordance with general principles of contract law. While the United States could conceivably refer to the entire federal government, as petitioner urges, the entirety and context of the NPA here makes clear that the term is used, as it often is, as one alternative way to refer to the United States Attorney's Office executing the agreement. Among other things, the NPA invoked the authority of R. Alexander Acosta, United States Attorney for the Southern District of Florida, and listed only officials of that USAO in the signature block, showing that the agreement was with the USAO, not the entire DOJ. While petitioner emphasizes the paragraph stating that Epstein sought to resolve globally his state and federal criminal liability, even as to his federal liability specifically, the agreement by its terms protected him from federal prosecution only in this district. The NPA's co-conspirators clause, which also agrees to forego certain prosecution of co-conspirators, cannot reasonably be construed as reflecting some global scope broader than the Florida-based state and federal charges that Epstein resolved for himself. It would be extremely strange if the NPA left Epstein himself open to federal prosecution in another district, as eventually occurred, while protecting his co-conspirators from prosecution anywhere. at the time the NPA was negotiated, DOJ policy barred USAOs from entering into NPAs that bound other districts unless they obtained the approval of those districts or the criminal division. That policy reflects the longstanding general rule that a U.S. attorney's area of responsibility is limited to his district. So, Alexis, this is what you were saying. Do you think it was clear on his face? And this is different from like Cosby, right? Because with Cosby, it's not like Maxwell relied on this language to provide incriminating information about herself to authorities. She can't say, well, you know, I relied on this language, so I was free to do whatever I wanted. It is different. It is a little different. This, you believe, is the stronger argument from the government.
So let's unpack that, because that was a lot, right? So here's the thing. Under contract law, the ambiguity, the vagueness, let's say the vagueness of the contract is going to be to the benefit of the person who didn't draft it. In this case, it would be Epstein. But the situation that we have here is that this agreement was entered into and negotiated. And I could see where there's a possible argument Epstein could say, if he was alive, that, oh, I thought it was for the whole United States, that I couldn't get prosecuted, nor could my co-conspirator. But here's the problem. He had an attorney, and the attorney, we're going to hope, should have known about this, and the attorney would have discussed that. There may have even been discussions about the fact that it didn't cover the whole United States. They may have even tried, his attorney or attorneys, to try and get that language or that approval to be put in there that it would be across the United States. But the way this deal went down, I don't think they wanted to go to other districts to get approval, because I think they would have gotten a lot of pushback, and this deal wouldn't have happened, because this went down kind of on this, the secretive end of it, as it appears to be. So, I mean, I think they knew exactly it didn't cover this. The discussion probably was to the fact, oh, we're going to enter this, it's going to go away, and we don't really have to worry about it because we're not hearing any noise from anybody else, is probably how it went down. Epstein was fully aware that he did not have that, I would assume, because he had good attorneys. I mean, they got this deal, right? This is a sweetheart deal. So, the problem is to make that, for her to make that argument, I think is a very weak argument to be made, when anybody that works in this arena knows that to be the case, as well as who signed off on it, as you mentioned. So I don't think that's a very strong argument, on her part.
I agree. I think that you make a great argument. I think they're making a strong argument about it as well. But they also make one more argument I want to talk about, where they say, this is just not a case for the Supreme Court. Quote, at all events, the case-specific interpretation of a particular NPA is not a matter that warrants this court's review. And that is especially true where district court and court of appeals are in agreement as to what conclusion the record requires. Indeed, this case would be an unsuitable candidate for further review for additional reasons as well. First, unlike the defendants in the cases cited in the petition for certiorari, petitioner was not a party to the relevant agreement. Only Epstein and the Florida USAO were parties to the NPA. Even assuming that a third party could assert rights under such an agreement with the government, but there is no evidence that the parties to the NPA intended for the co-conspirators clause to benefit petitioner. The government was not even aware of petitioner's role in Epstein's scheme at that time. And then they also doubled down on the prior argument by saying even if the Florida USAO had purported to bind all other USAOs in the NPA, it would have lacked authority to do so. Under DOJ policy at the time the Epstein NPA was entered, a USAO could bind other districts in an NPA only if it obtained the approval of those districts or the criminal division. So this overarching argument, don't even hear the case. Don't even just decide it in our favor, Supreme Court. This is not even a case you need to pick up. You think the Supreme Court's going to agree?
Well, the Supreme Court does get to decide what they want to hear. I mean, I don't know what they're going to do, because this particular Supreme Court has decided to pick up cases that I personally think that they should not have, gotten involved in. So I'm not sure what this particular Supreme Court, but generally, if you have consistent opinions between lower courts, those aren't generally things that the Supreme Court necessarily is going to pick up to make a decision on. But who the heck knows with the Supreme Court?
Alexis Rosenberg, thank you so much for coming on. I appreciate you breaking down the finer details of what's happening in the latest with Ghislaine Maxwell.
Thank you for having me.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.